Okay, let's see if this works. I'm testing out something new today, where I'm using the same screen to go live on Instagram, YouTube, and Facebook. Um, so just, give me a minute, guys. If you guys can see me on Instagram, comment, let me know you can see me. Just trying to see. Let's see, preview. Okay, let's try this and see if it's working. Um, okay, let's test this out. If you're on Instagram, can you see me? Let's see if this works. Um, Let me know in the comments if you're on Instagram and you can see me, because I'm trying to go live using the same screen. I'm not sure if it's working, but comment and let me know so I know that you're on here, because it's still showing me two different screens. So I might need to move one screen over. Let's see. Let's move this one here and have this one here. Oh, okay. You guys can see me on Instagram. Oh my goodness. Okay, so this works. But is it clear? Because it looks blurry on my end. If this works, this is great because, I was just sick and tired of using two different screens, like one on my phone, one on the computer. Now I, can look at you guys at the same time and answer questions at the same time. Okay, so it's clear. Awesome. All right, guys. Good morning, everyone. How's everyone doing? So let me introduce myself. My name is Aisha Chidole, and, I'm an immigration lawyer. I represent clients in all 50 states in the United States, internationally. With the Immigration Matter, we focus on humanitarian-based cases, although we do take normal cases as well. But we do a lot of VAWA cases. We do a lot of T cases, U cases. We also do marriage-based cases, naturalization cases, appeals, waivers, all of that good stuff, removal of conditions. So we'll be happy to help you. Our phone number here is 407-995-6567. You can also send a WhatsApp to 404-333-8751. Okay. All right, guys. So let me... Someone asked a question. Y'all are just jumping right into the question. So let's go right into the question. Someone says, is it necessary to have photos with my partner as part of the process of removing conditions as divorce? I deleted all the photos in one of our many discussions. Definitely, certain people, it's in their personal nature to react or be reactive when they're in conflict. It's not a requirement to have pictures. However, pictures can help to tell a story of your relationship. So it's not a make it or break it. To me, if you are submitting pictures, your pictures need to make sense. If you're sending pictures just of, both of you just eating at a restaurant today and tomorrow you're in the house cooking food or something like that, those pictures really don't make a difference in your case at the end of the day. When you're removing conditions on your green card, what you really need to focus on is proof that you're doing life together. And that could come in the form of many things that are memorialized in writing. So, i.e. bills and things that financially entangle you guys, filing of taxes, if there's a reason why you're not filing taxes. Another way that you're sharing your finances, whether it's joint bank accounts, health insurance. Health insurance really carries a lot of weight, just because health insurance, does cost money, and, it's taken out of your payroll. So they look at that as something that's indicative of, you guys being in a good marriage, or bona fide marriage, utility bills. If you're sending pictures, from conditional removal type cases, the best kind of pictures to send really are, pictures that maybe you guys went on a trip together, you guys went to visit sites that probably require like admission costs. You went to Disney, you went to Universal Studios. I'm just throwing out different examples. You celebrated a birthday with friends and family, or you were at an aunt's picnic. So those are the kinds of pictures to send, but it is not a make it or break it in any case for that matter, whether you submit pictures or not. It's just something that can be helpful, but it is absolutely not a requirement. Okay, so Adewale on YouTube says, good morning. When you get your work authorization after biometrics in the when do you get your work authorization after biometrics in a valid case? Well, it all depends. It all depends on if you filed an adjustment of status with your application and requested a work permit. But a good timeline is usually 4 to 9 months from your initial submission of your application. So, a lot of people right now, we're definitely seeing 4 to 6.5 months on average. There are always going to be a sprinkle of people who get there a little earlier, but this is kind of the window or the timeline that you fall under. Someone is asking WhatsApp number. So let me put the phone number right here. See if I can pin it. Is 407-995-6567 or WhatsApp 404-333-8751. Okay, so I pinned my phone number down on, oh no, did I get disconnected from Instagram? Okay, looks like I got disconnected. Did I get disconnected on Instagram? Let's try this again. So this is the thing about trying something new, because I think I got disconnected. Oh my goodness. Let's try this again. Sorry guys. Let me see if I can get it back. Okay, it's saying I'm here, but it's showing me that I'm disconnected. This is driving me crazy. Okay, maybe I need to go back to my phone because this is driving me crazy. Okay, so if you sent us a WhatsApp, you can simply call us. Our WhatsApp has an auto response where basically it has our phone number to call us or for you to put your number, but it also has a link for you to schedule a consultation if that's what you're trying to do. So you can click the link and schedule a consultation that way. Is a divorce by mutual consent or a divorce based on irreconcilable difference better for immigration? It really doesn't matter. Doesn't matter at all. Yeah. Davis says, good morning. Good job always. Thanks for all that you do. We truly and truly appreciate you. God bless you. Thank you so much. Can a U.S. citizen petition for a niece or a nephew? This is a good question, but the answer is no. A U.S. citizen can only petition for the following family members: a parent, a child, a spouse, and a sibling. Those are the only 4 people that a U.S. citizen can petition for. And depending on the age or which connection you have, you could be considered an immediate relative, or you could be considered a family preference. So for instance, if you're a U.S. citizen and you're petitioning for a child under 21, or for a spouse, or for a parent, you're considered an immediate relative, meaning there's no wait time, meaning that you can submit an I-130 and an I-485 right away at the same time. However, if you're petitioning for a sibling, sibling has to be, under the family preference category. It's called F4, and so that can take some time. There's a wait time for that, but that was where it will fall under. And also, if you're petitioning for a child that's over 21, that also takes a different amount of time. And also, if you're petitioning for a child who's married, that takes a different amount of time. But those are the only 4 family members a U.S. citizen can petition for. You cannot petition for a niece or a nephew or a grandma or grandpa. Okay. I didn't file VAWA concurrently with I-485 and I-765. It's been 35 months. What should you do? What should I do? Well, why didn't you file it? Were you married to a U.S. citizen? If you were married to a U.S. citizen, you definitely want to, if you were married to a U.S. citizen, you definitely want to file it now. Okay, you definitely want to file it now. You can do an inquiry on your case right now. So I think I mentioned this in my last live. With USCIS now, they're allowing VAWA applicants with certain requirements to make phone calls. So you can make a phone call and ask for an update on the status of your case. So you can call them now without having to send a letter. Before, you couldn't do that. Prior to this month, you couldn't do that. So this is something new they're trying. There are some things and identifiers that they will require from you when you're on the phone, but we're definitely doing it here at our firm, and we're sort of getting quicker response than sending hotline email. So you might want to try that, okay? Do you wait for an I-797C before you file for a work permit? For I-777, this is the example of where we always say it's better not to do something that you don't know how to do. You should be working with a lawyer, someone that is competent enough to assist you with your immigration matter, because immigration is something that any little error can affect you or can be to your detriment, including deportation or separation from your family. If you were using someone will tell you that an I-797 is basically the sheet in which every form that USCIS sends to you is on. An I-797 is simply just a sheet where everything they send to you, whether it's your receipt, whether it's your approval, whatever it is, it will be sent on that form. So to answer your question, what your question doesn't exist, because an I-797 is what the sheet, the paper that you get, whether it's a receipt or filing receipt for anything that you file. So not really sure what your question is, but if you're doing an adjustment of status, you should be doing a work permit with an adjustment of status at the same time. Good morning. What if your spouse writes immigration to withdraw sponsorship on your case? What next? Your spouse can write a letter to withdraw sponsorship. You can't force a spouse to petition for you. But one thing that you might want to consider is getting screened to see if you are eligible to self-petition based on VAWA. If you are eligible to self-petition based on VAWA, you can most likely hold that case in abeyance and try to petition and merge those two cases together. Okay. What is your opinion regarding the attachment of additional documents after filing without waiting for an RFE? It just depends. It depends on what you're amending, and making sure that it's getting to the right place and knowing how to send it to the right place. But we do amendments all the time here when people come to us after maybe they've done something or someone else did something and they want to know if they should be doing something more. We've definitely done amendments for people before. Okay. Good morning, attorney. Are visas current yet for VAWA for green card holders? So Kiara, I don't know if you were here last week. This is what I mentioned. As of August, so not today, in August, the priority date becomes anyone that submitted their petition, i.e. your I-360 or an I-130 before June 15th, 2024. We're waiting to see which chart USCIS is going to use. I suspect they're going to use this chart, the one that specifically states that. What that means is that in August, there is a strong chance that if you already submitted your VAWA application based on you being married to a green card holder, and you submitted it before June 15th, that you will be able to now add in your adjustment of status application, which will allow you to get your work permit, your travel permit, and your social security number, which is a big deal for a lot of people, Is it typical to get an RFE and an I-765 and I-131 forms? I'm asking for a friend. If it's done correctly, it's not typical that you would get one, but sometimes it is, or sometimes, let's say you sent your 765 and you're missing something there, they can request it, i.e. let's say you didn't send your passport pictures, they might request that. All right, I guess this is a side conversation, so I don't know. I can't see the first part of it. Can your children apply for their visa if you have a 10-year green card? And will they get through? And can I file for them at the same time? So when you say apply for their visa, are you talking about like a B1, B2 visa? Are you talking about an immigrant visa? I'm not really sure what you're referring to, but if you're talking about an immigrant visa, which is essentially a green card, whether you have the 10-year or not, they can certainly apply for one as well. It's just that it will take some time for them because you're a green card holder. What is your opinion if your spouse lives in another state from the husband because of her graduation program? Does this affect them during the green card interview with USCIS? I think this is a really good question because I know, you know, a lot of, let me scroll back. This thing is scrolling, so it's moving so quickly. You know, because I know that sometimes, you know, life doesn't permit people to live in the same place at the same time. Now, if you are doing a vow of self-petition, cohabitation at some point is 100% a requirement. In a marriage-based case, cohabitation is not a requirement, i.e. people who live outside the country and are filing for their spouses. However, you have to show that it makes logical sense why you're not living together right that very second. So in this case, if she can document and show, look, you know, I'm in a program, I'm in a graduate program, you know, I can't relocate because this program is, you know, is local to this place and I'm trying to finish, and my spouse can relocate because I don't know where I'm going to get a job. And so I don't want my spouse to uproot his life to this new location until I graduate. And we know that makes sense, you know, as long as you're able to provide other proof to show that you guys are doing life together. I mean, we've gotten many people, and I'm sure if they're on live, they can attest to it, approved for marriage-based cases that don't live together. You know, what you don't do is you don't lie about it. You just explain why you're not living together. Okay. Oshana on YouTube says, if you keep your name, does it have any effect on your process? No, it doesn't have any effect on your process. There's no requirement. There's no requirement for you to change your last name if you get married. I mean, we're in 2024 in the United States, so this is not a requirement. You can keep your name, you can change your name. It's really all up to you. Okay. When a U.S. petitions for a married child, can they include grandchildren over 21 on the I-130 application? Those children will not be eligible, you know, for a green card based on, you know, the family preference category. Okay. I was placed in administrative processing after my spousal interview. It's been 7 months and Lagos Embassy has not reached out. What can I do? I don't know if you're working with a lawyer, but, you know, usually it does an email hotline where that can, you know, be researched and checked just to see or check the status on the case. What's going on? Do they need something else? What kind of investigation are they doing? Just so that, you know, we can keep it moving. All right, let's see what else. I petitioned for my sister and her husband in 2007, and they're still waiting. What can we do next? You just have to follow the visa bulletin. Because I'm on live, I can't go on the visa bulletin right now to tell you what to expect from a timeline perspective. But generally, sibling petitions can take anywhere from 16 to 20 years, depending on what country you're from, what country the person you're petitioning for is, but, you know, your process seems to be moving normally. What will happen is once your I-130 gets approved, you won't be able to do the immigrant visa application through NVC until the visas become available, which again can take 16 to 20 years for a lot of people and siblings. I was divorced before I got my green card. I have a work permit and a social security number. I'm single with 2 kids from a previous marriage, and now we are here and I don't know what to do. So do you mean that you didn't get your green card? Is that what you mean? But your case is pending. If your case is pending and all you've gotten is your work permit and your social security number, we can certainly screen you to see if you're eligible for another immigration benefit. Call the office, okay? How long does it take for deferred action for those who were born here with medical issues? I already did fingerprint and provided evidence. It's been almost 2 years. So there's really no published timeline for deferred action, just because deferred action is a decision only made by the field office director. So it's a discretionary benefit, and every field office is different. If your case, I would say, has been pending for more than like 9 months, it's a good time to try to seek congressional assistance or an ombudsman assistance to see if they can reach the field office director and help them make a decision, especially because it's health related. Is it normal not to receive a receipt notice after 5 weeks of submitting your packet? Yes. Most cases take 4 to 6 weeks for receipt notices, sometimes even longer. I have heard, I haven't really noticed it per se in my practice, but I have heard from some of my colleagues that some adjustment of status cases and some valid cases are taking a little bit longer in the last couple of weeks to be receive their receipts. So I don't know, maybe you fall in that category. Can you enter and exit the US on a B1, B2 visa if your adjustment of status has been filed? No. So this is how it works. Once you enter into the United States on a visitor's visa and you submit an adjustment of status application, you cannot leave the country until you apply and get approved for an advanced parole, which is a travel permit. Once they approve your advanced parole, then you can leave the country and you will be entering back into the country with the advanced parole, not with the B1, B2. You'll be entering back with the advanced parole that gives you permission to re-enter because your case is pending. So don't leave until that advanced parole is approved, okay? Can a pending Form I-485 be withdrawn before the divorce starts? You can withdraw an I-485 at any time. What if you only filed an I-130 petition? Would your priority date be the one on your I-130, and would your date be current? So your I-130 date receipt will have your priority date under the section on the top left where it says priority date. Whether it'll be current or not is all dependent on what kind of case you filed and when you filed it, so I can't answer that question. Is false claim to citizenship to get a driver's license? Can you get a green card application denied? Absolutely, we've seen that happen. False claim to citizenship for any reason at all. You should never claim to be a citizen, guys. This is one of the worst death sentences to a green card or to citizenship that you can give yourself. You should never, ever claim to be a U.S. citizen if you know you're not a U.S. citizen. It is a bar to a green card. I mean, the only way that you can overcome that is, let's say you're a U visa victim and you're a victim of a serious crime and, all of that. So don't do it, okay? Aphrodite, if you'd like to schedule a consult, yes, it's best to call 407-995-6567. If you've been out of the United States for more than 3 years with a green card, however, you have re-entered, when will you be eligible to file? You'll be eligible 5 years from the date you entered, because basically you've restarted your count. If you're doing it based on marriage, then it'll be 3 years. So it just depends on how you did it. Are you taking new clients, and what countries do you specialize in? For I-130s, we take clients in every country. We don't have any, we are not limited to anyone who is eligible. We are willing to accept you as a client. And yes, we are always taking new cases. Should I withdraw my I-130 petition if the person moved to the States on their visa? No, you should not withdraw your I-130. Your I-130 can be converted. Your I-130, you need it whether they're in the States or whether they're outside the country. It doesn't matter. What will make the difference is that you'll go from consular processing to adjustment of status with that I-130, but do not withdraw the I-130. Can a pending Form I-485 be withdrawn before divorce start? I think you asked this question already. I filed for VAWA in 2017. So far, I haven't gotten an approval or prima facie. Should I be worried? Yes, I will be worried. We definitely need to do a full year, see what you submitted, and an outreach must be made to USCIS because that's going on 7 years. That is too long a time. Let's even make sure you have a file, in there. That's definitely too long. So definitely be worried. Okay. All right, guys, I do have to jump off. The only thing is, I don't know if this live will be able to be saved. because of the method in which I'm using to go live today, but we'll see. I hope you guys have an amazing day, and I will be back on live tomorrow. Probably at 10 or 9:30. I'm not sure because I got to see my calendar. So if I didn't get to answer your question, please go ahead and come back tomorrow or schedule a consultation if you're a client of mine. I don't answer client questions on live. It's confidential information. Reach out via your client portal. All right, guys, have a great day. Bye.